TALA is Texas Accountants and Lawyers for the Arts. TALA believes that regardless of income, artists should have access to professionals to get the legal and accounting services they need to further their career.
You're trying to share the beautiful things that you've made, with the world, and so many people take advantage of that. So it's really good to have, somebody like TALA that can help you as best as possible to protect yourself.
TALA was, instrumental in helping me make some changes to my then current record contract, and did it quickly and efficiently.
I have TALA lawyers working with me on copyright. I now have 3 trademarks established. I had a contract negotiations with a big project. They helped protect me.
Our services are offered to financially qualified artists, dancers, musicians, writers, actors, inventors, arts nonprofits.
So when an artist or an arts nonprofit wants to work with TALA, they become a member. There's an annual membership fee.
And when an issue arises, they can submit an inquiry to TALA. TALA is going to send that inquiry, whether it be accounting or legal services, to all of our volunteers, where they're going to be matched with an attorney or an accountant. They're going to get answers to some of their questions on a pro bono basis.
The patent process is a fairly long and labor-intensive and, quite frankly, very expensive process. If you're just at home and you come up with this great idea and then you build a prototype, you don't have the financial backing at that point to then go through this lengthy and expensive process, which is where TALA comes in with their program, and it provides those services and sort of bridges that gap.
I really think that it's a special organization because so many of our volunteers are like me and they're passionate about the arts in Texas. And so people that are volunteering with our organization, they want to help Texas artists.
The role of the artist is so important. They make us think about the world that we're in. They challenge us to see things from a different perspective. They break us out of the monotony and the routine of daily life. They inspire us. They bring us closer to our humanity and what we're actually here on this planet to do. So supporting artists is something that's very important. They have an important role in society, but it's also a business that they have to figure out. So the more that you can contribute to an organization like TALA, the more that artists such as ourselves, that we feel like we have something great to share with the world.
We offer free seminars around the state on topics like budgeting and financial planning and taxes.
The more you know about your taxes and what you can write off, the more money you can save, and again, the more sustainable you can be.
Having your mental space to create while not worrying about this stuff which is so deeply involved in a totally different field, like law or business. You also have to understand your limits, that you can't do everything and know everything.
So hiring out more people to help me, they can help me with my vision, the more successful I can be, and the more time that I get to work and be an artist.
TALA is really important because up-and-coming artists and arts nonprofit organizations may not actually be able to afford lawyers at their full rate. And it helps them get that help so they can get on their feet in the beginning and start the business the way they should.
That's all we want, is to increase the creative economy in Texas and just let the artists be able to create and not worry about these legal issues. So it's just, people that appreciate the art trying to help the arts.
Good evening. Thanks for joining us, and welcome to Legal Essentials for Live Streaming. I'm Elisa McCain, Executive Director of Texas Accountants and Lawyers for the Arts. Since you just watched a video about our attorney matching services, I'm not going to go into detail about that now. You may find more information on our website at talarts.org, or you can send an email to info@talarts.org. There is a financial qualification for matching pro bono services, and that information is also on the website. I do want to mention that TALA is continuing to waive our membership fee for legal assistance requests related to the pandemic. You'll find more information about that under the COVID-19 section on our website. And you must be a Texas resident to use TALA's Pro Bono Matching Program. Webinars allow us a much further reach than our typical in-person events. Many of you might have attended an event in Dallas, Houston, or Austin, and we've gotten to meet you. Since times have changed, we've had to go to a different format. Tonight, we're welcoming guests from numerous cities throughout Texas, plus attendees from outside of Texas from places like Providence, Rhode Island, San Diego, Los Angeles, St. Louis, Des Moines, Jacksonville, Milwaukee, Cleveland, New York, Lawton, Akron, Nashville, plus Toronto and Leeds, UK. We're thrilled to have everyone, and welcome to folks that are attending a TALA program for the first time. It's just so encouraging to see how the creative fields are working together and pushing through in this time that has been so unexpected and so challenging. Tonight, we'd like to thank our supporters, the Cultural Arts Division and the City of Austin, and the Texas Commission on the Arts and the National Endowment for the Arts. Without their support, we wouldn't be doing these things every day, and we really appreciate their ongoing support, especially during the pandemic. Turning to tonight, our speaker is Austin-based attorney and TALA board member, Gwen Seale. Gwen is a graduate of SMU Dedman School of Law, and she practices entertainment at Mike Tillison and Associates in Austin, Texas. While at SMU, she interned at 2 venues in Dallas in the Deep Ellum District, Trees, and the Bomb Factory. Currently at Mike Tillison and Associates, she drafts and negotiates contracts related to music, sports, entertainment, and assists clients with copyright and trademark registration needs, as well as a whole bunch of other entertainment law and non-law advice that she gives on a daily basis. Gwen's become quite an expert at the intersection of technology and entertainment. Gwen is quite an expert, and she's been well-versed in many of the online platforms that monetize music and art, which has become no easy task. We're extra fortunate to have Gwen tonight. This seminar content is taken from research that Gwen has been working on for the past few months to present specifically to Texas entertainment attorneys in November. So you all are getting access to this info before anyone else. And on that note, this presentation will be available to watch after tonight. However, we will not be sharing the recording until after November 21st. Throughout the presentation, you may write questions in the chat box, and if time allows, we'll try to cover some of those questions. It's highly probable, though, that your question may be answered in the course of the presentation. Questions that have a more general nature are a better fit for tonight's presentation and webinar, as we're not able to answer specific legal advice for individuals. If you have a very specific need, again, it may be possible that you can join TALA and get one-on-one pro bono assistance. So with that, I'm going to turn it over to Gwen, and we'll get started.
Hi, everyone. Thank you so much for joining me tonight as we talk about legal essentials for live streaming. There's a lot of information to get through, so we're just going to dive right in. If my PowerPoint slides will move. There we go. Live streaming is an understandably confusing realm. You had millions of artists who were forced to pivot to this medium in just a matter of weeks. You have the major live streaming platforms that implement different licensing structures and monetization criteria. Matters further aren't helped when you have these live streaming platforms releasing new guidelines that are just wholly confusing. So all of this has kind of created a perfect storm, right? And so, despite all of this chaos and confusion, live streaming really is a powerful tool, and it enables artists and creatives to be able to reach their fan bases in the midst of this pandemic lockdown. And I know that a lot of you have questions, and I've been receiving questions for the last few months. Some of the most common questions that I've been receiving include things like, can I perform a cover song on Facebook? Or am I able to play a DJ set over Twitch or on YouTube? Or things like, am I just completely covered as it relates to live streaming content because YouTube has Content ID? So these are some of the questions that we will be talking about in depth tonight. So we are going to begin by discussing some copyright basics. And copyright basics are just really important because it will help you to understand some of the legal issues connected with live streaming. Next, we will go into music licensing in connection with audiovisual works because live streams are audiovisual works. Then we'll talk about the distinction between archived versus non-archived live streams. Archived live streams are live streams that stay up on a platform to where you can just replay them back on demand after the performance is finished, whereas non-archived live streams disappear from a platform once the performance has concluded. Then we will begin to go into some of the platform licenses, like what licenses do platforms have with rights holders or with different collection agencies. And then we will also kind of talk about some of the tech basics too. And an understanding of just some of the tech fundamentals is really important because that really ties in with not only monetization on the live streaming platforms, but also the licensing structures themselves. And then finally, we will explore some interesting legal issues related to ownership of live streams, along with revenue sharing and commissions, things which really have not been brought up so far yet that I've seen, but that I expect over the next few months to a year will be some points of potential contention. I think it's fun to look at some of the live streaming statistics since the commencement of the pandemic. Just between March and April, the sector increased by 45%. And you had Twitch, which is the largest live streaming platform, that increased its live streaming watch hours by 50% just during the month of March because everyone's at home and they have nothing to do, right? And Twitch used to be just a platform by which people would live stream themselves playing video games. But as the lockdown happened, you have a lot of artists and musicians, creatives, who decided to start using the platform to live stream their sets. And in fact, the music and arts category on Twitch ended up rising by 524% in March. Facebook also, their live streaming usage increased significantly as well by 50% during March. And that's just because it's so easy to live stream on Facebook. And artists, I imagine most of you have put a lot of years worth of work into expanding your fan base on Facebook. And live streaming, while it has exploded, it's not a new phenomenon. Lots of music festivals have been incorporating live streaming into their programming for years, like Austin City Limits or Lollapalooza or Coachella. And in fact, in 2019, Coachella was live streamed for both weekends of performances, and that involved 3 stages, over 60 performers, and that boasted a viewership of over 82 million people just during week 1, which is pretty impressive. Now let's shift over to some copyright basics. Some of this might be a refresher for some of you because I noticed that quite a few lawyers signed up, but for those of you who don't know copyright, this will be something new. Now, copyright law protects original works of authorship fixed in a tangible medium of expression. So at the point at which you write some lyrics down on a piece of paper, that is going to be a copyrightable work because it is fixed in a tangible medium. Same thing if you maybe recorded a voice note on your phone. Same thing, you have a copyright there at the point at which it is on your particular device. Now, works of authorship can include musical works, including any accompanying words, also known as musical compositions, sound recordings, and audiovisual works. And those 3 categories are the main categories of copyrights that we will be discussing today. Now, as it relates to music, there are 2 distinct copyrights. There's the musical composition copyright, then there's the sound recording copyright, also referred to as the master. The musical composition is composed of the lyrics and the melody. So let's say I write the lyrics and melody to a song. I am the songwriter and I own the musical composition copyright. And because I own and I control this musical composition copyright, because I wrote this, I also operate as the music publisher. And as the music publisher, my job is to go out and try to exploit that composition in whichever way I please. Maybe I try to get a popular artist to cut the song, or maybe I decide I want to license the song for use in a film or TV show or something like that. Then you have the sound recording copyright, and which is also referred to as the master. Let's say I decide to record myself singing and playing piano. That sound recording, I am the performing artist, I own the copyright in that sound recording, and as the copyright owner, I operate as the label. And as the label, I can go out and exploit that sound recording in whichever way I want to. Now, just note that when you're dealing with collaborations, if there is nothing in writing between the parties collaborating, then the parties are going to jointly own the copyrighted works. So let's say Elisa decides to write the lyrics to a song and I write the melody. We will jointly own that particular musical composition if there is nothing in writing. And that means that both of us are the songwriters and both of us will be the music publishers. Similar on the sound recording side. Let's say Elisa is playing guitar on a track and I am singing. Elisa and I are going to jointly own that particular sound recording. We are both the performing artists on that sound recording. We are both operating as the record label. As copyright owners, you are afforded certain exclusive rights, which I'm just going to kind of run through. You have the right to reproduce copies of the work, the right to prepare derivative works based upon the work. So derivative works being like translations or rearrangements, or the right to sample and mash up the work. You have the right to distribute copies of the work, the right to perform the work publicly, the right to display the work publicly, and the right to transmit sound recordings digitally. Now let's just talk about some basic music licensing principles as it relates to audiovisual works. So just as there are two copyrights as it pertains to music, if you're wanting to use a piece of music in your audiovisual work, like a TV show or a film, there are going to be two licenses that you'll need. So let's say that a party is wanting to use a particular piece of music for their film. That party is going to need to get a master use license in connection with the sound recording, meaning that party will need to go to the record label that owns or controls that sound recording and request a master use license. The party that is wanting to use the music and the film will also need a sync license for the musical composition that is embodied in the sound recording. And so that means that that party will need to go to the music publisher that controls that musical composition that's embodied in the sound recording and request a sync license. Now, that is generally how things work, but things changed once you had platforms come about that incorporated user-generated content. User-generated content being content materials that are uploaded to various platforms with that content containing works that the uploader does not own or control the rights to, and that the platform does not own and control the rights to. And so, for example, like YouTube is one of these platforms. Facebook is one of these platforms. Twitch is as well. And so you have these platforms and they try to avoid dealing with all of the licensing, like having to go out and get individual master use and sync licenses, by utilizing Section 512 of the Digital Millennium Copyright Act, also known as the safe harbor provision of the DMCA. And so Section 512 essentially provides to online service providers a safe harbor from liability for hosting infringing content as long as certain conditions are met. One of such conditions being that that platform, that online service provider, establishes a notice and takedown system. And I imagine that probably some of you have experience with takedown notices. It might be that in the past you were using some works that you might not have owned or controlled, and so you ended up with a takedown notice from the rights holder. Or it might be that someone used some of your works without your permission, and thus you sent a takedown notice. So the rationale behind Section 512 is that basically platforms would cease to exist due to the sheer amount of liability that stems from user-generated content. So platforms will try to hold on to 512 as long as they can, but then they deal with rights holders who are upset because they're not getting permission for the use of their works, and the rights holders aren't making any money from the use of their works. And then it ends up with lots of takedown notices that parties are having to deal with. And so generally speaking, eventually, the platforms will enter into blanket licenses with rights holders that allow the rights holders to monetize or block the use of their works through copyright management and detection technology. Now, I talked about this really briefly at the beginning, but note that there are two types of live streams. One is the pure live stream, that's just what I call it, and it disappears after the conclusion of a particular performance. Then you have the archive live stream, and the archive live stream remains on the platform after the conclusion of the performance. And so you'll see on this slide here that this particular thing that was live streamed in the past, and it's still available on Facebook. So that means that it is an archive live stream because people can go back and replay it. And the distinction is important because each of these live streams invoke different licenses. So let's first start off with the pure live stream and utilizing sound recordings that you might not own or control. So let's say you are live streaming on a platform, like a social platform like a YouTube or a Facebook or wherever. That platform should either have master use license language and agreements with labels and distributors, but note that even if there is master use license and agreements with labels and distributors, there could be some limitations in the scope of that master use license language in the form of time or multiple song restrictions, meaning that the labels might say, hey, only a certain amount of songs can be used in a live stream video that come from our catalog, or only this chunk of time from a particular song might be able to be used in a live stream that occurs on your platform. Or you have the situation in which hopefully the platform would have blanket licenses with labels that allow the labels to monetize or block the use of their works, like their recordings, through a detection and copyright management system. And so this slide, you'll see this mainly as it relates to DJs, because a lot of the time DJs are going to be live streaming sound recordings that they don't own and control. And so that means that the platform the DJ is using needs to have licenses with these labels. And what makes it even more problematic is even if the label does have licenses with the platform, like I said, there could be limitations to how their recordings can be used. And then you also have the other issue of labels deciding that they want their recordings blocked from being able to be used. So ultimately, as you'll see throughout this presentation, DJs are just kind of in a hard place if they're using sound recordings that they don't own and control. And further, if the DJ is wanting to do like a live stream on her own website, she is going to need to actually go out and get all of the licenses, all the master use licenses with the labels herself for the use of those sound recordings in a live stream on her own website. So that's why a lot of people decide that they want to just go ahead and use a social platform, because then that means that if the platform has the licenses, then they're not going to have to go out to the individual rights holders and get the licenses. Now, when we're talking about the pure live stream, non-archived, and musical compositions, the platform in which the live stream is being exhibited is going to need a blanket license with the performing rights organizations, performing rights organizations, at least in the US, being ASCAP, BMI, CSAC, and GMR. And that's because a live stream is a public performance of music. Now, note that no sync license is implicated because the live stream will disappear upon the conclusion of the performance. However, just note that when we're talking about a pure live stream, a pre-recording that is later streamed live is not technically referred to as a pure live stream. That actually falls into archived live streams because it's been stored somewhere. So I know we're kind of talking semantics here, but that's just something important to recognize. And also note that if a performance in which you're utilizing non-owned or controlled musical compositions is theatrical in nature, so maybe an example of this would be a musical theater group that's doing some covers of popular songs in like a really dramatic way, you might be dealing with a grand rights issue. And the performing rights organizations don't license grand rights, meaning that you would have to go to the various music publishers which own or control the particular compositions that you're wanting to use in a theatrical nature and get that permission. So when we're talking about pure live streaming platforms, with both YouTube and Twitch, you can go into the settings on each and elect for a live stream not to be archived. Facebook is a different story, however. Now, archive live streams, meaning live streams that are basically available on demand for people to just replay. So we're dealing with the same licensing issues as sound recordings, but on the musical composition side, along with needing the blanket licenses with the performing rights organizations being ASCAP, BMI, CSAC, and GMR, because we're dealing with a public performance of music, sync rights are implicated. And that means that there's either going to need to be sync license language and agreements with the platforms and with the publishers and publishing administrators that own and control the various musical compositions that are going to be utilized on the platform, or there needs to be some sort of detection and copyright management system for music publishers so they can choose how their works are used, whether the works are monetized or whether the works are blocked. So just keep in mind when we're talking about archived live streams and using non-owned or non-controlled musical compositions. So just think, for example, just doing covers, that platform is going to need licenses in place with music publishers for sync use. And that extends out to your own website. So if you're doing a live stream on your own website in which you are doing covers, then you as the operator of the website, you're going to have to go to those music publishers and request sync licenses if you want that live stream to be archived, meaning able to be replayed. So a tech fact that we will explore more in depth in just a few. While detection and matching technology like YouTube's Content ID is able to recognize and match sound recordings to applicable rights owners, it is much more difficult for the technology to detect and match musical compositions when they are covered by other performers or just compositions in general as it relates to live streams. So we will explain that and explore that in more depth in just a few. Now, archive live streaming platforms. YouTube, Twitch, and Facebook all have archiving capabilities. And in fact, this is the only option with Facebook. So if you don't want your video, your live stream video to be up on your page after the performance is concluded, then you will just have to go to your Facebook page and delete it. Now, let's start moving into the tech basics and some of the licenses that the platforms have with rights holders. So YouTube is a great starting place because they were one of the first platforms to deal with licensing issues as it pertained to user-generated content and audiovisual works. And so with YouTube, just brief background on the history, you have the Viacom lawsuit. And you have some companion class action lawsuits that were filed by music publishers against YouTube because the platform was hosting a lot of videos that contained sound recordings, compositions, and just other IP that YouTube didn't own and control, and that the users who uploaded the content didn't own and control. And so as a result of these lawsuits, YouTube ended up developing its detection and copyright management technology for rights holders, like record labels and music publishers. That technology is called Content ID. And so over time, rights holders have delivered their IP, YouTube refers to IP as assets, to Content ID. And so each asset, each piece of IP, has its own unique digital DNA that's ascribed to it. So that means that if a person then uploads a video to YouTube, that video is then scanned against all of the other files within Content ID to see whether the particular video contains any assets that Content ID is able to recognize. And so then if the uploaded video does contain one of these assets, then Content ID will apply the policy that the asset owner has chosen regarding the use of the asset. And asset owners, using YouTube's content management system, can choose whether to monetize or track or block the use of their assets on the platform. Now let's just talk about this in terms of an example, because I know that this is pretty content heavy. Let's say I upload a video of myself, I don't know, cleaning the house. And in this video, there is a sound recording that I don't own the rights to, along with an underlying musical composition that I don't own the rights to. So when I upload that video to YouTube, if that particular label and particular music publisher have access to Content ID, then they've been able to basically tell the technology, I either want to monetize, track, or block my recording or my musical composition. And so let's say that the label has decided that the label wants to monetize the use of that sound recording. But the music publishers decided, you know what, I actually want to block the use of my musical composition. Well, then at the point at which my video is uploaded, Content ID will hopefully recognize these assets, and then it will end up actually blocking the video, meaning that it will just be like a black screen, or you'll be able to see the moving picture of me cleaning the house, but the audio will be muted. And that's because in the case of multiple asset owners choosing different policies, YouTube will go with the strictest policy. And so blocking is the strictest policy. Note that YouTube does have blanket licenses with the performing rights organizations like ASCAP, BMI, CSAC, GMR. And also note that music publishers or publishing administrators or aggregators with Content ID access have the ability to add data pertaining to musical compositions embodied in sound recordings in YouTube's content management system. So I know that sentence is kind of content heavy, so let's explore that a little bit more. So a record label decides to upload a reference file that pertains to a particular sound recording that the label owns. At the point at which that's in Content ID, the music publisher that owns and controls the underlying musical composition is able to go into YouTube's content management system, provided that the particular publisher has met the threshold to be invited into YouTube's Content ID content management system, and then we'll end up adding the data pertaining to that particular musical composition in that reference file data for the sound recording. And so that basically means that musical compositions are going to be tied to sound recording assets in Content ID. And as a result, that makes it nearly impossible for the technology for Content ID to detect covers. And that's because a cover is a different recording of a musical composition. It also means that as it just relates to performing a musical composition on a live stream, that it's going to be difficult for the technology to detect that musical composition because all of the composition data is all tied into individual particular sound recording files. And when you perform a composition on a live stream or you perform a cover, that is going to differ in tempo or pitch or length. And so the further away the sound is from the original sound recording reference file, the less likely it will be for the technology to actually be able to detect the musical composition. And that's problematic, right? Because then that means that publishers can't decide whether or not to monetize or block the uses of their compositions when they're included in live streams, or when covers are being uploaded to YouTube. And that further means that if the technology can't detect the compositions, then how are the PROs going to know, or how are they going to know who to pay, which composers and which publishers to pay whenever a live stream occurs or whenever someone uploads a cover to YouTube? Because it's not detectable. The technology just can't detect it. Now, YouTube has this melody match software, but it still is needing some work. And at least as of right now, really there isn't a platform out there that has really solid and sophisticated detection technology as it relates to musical compositions. Instead, everything's all tied into, all the composition data is all tied into sound recording reference files. Now, let's shift gears to Facebook. I like looking at the various platforms on kind of like the YouTube timeline. So you had YouTube, and they had the Viacom lawsuit and all the associated class actions. Those were all filed back in 2007. And so between like 2007 and like 2012-ish, you had all of that. Then Facebook is like, I don't know, 5 years or so behind YouTube as it relates to licensing issues and those sorts of related problems. And so you actually had in fall of 2016, the NMPA releasing results of the study that they did. And in this study, it showed that there were 887 videos that utilized a lot of the top 33 songs at that particular time in videos on Facebook, and that totaled to over 619 million views. And there were no licenses in place between Facebook and the music publishers or with the labels at that time. And as a result of a lot of backlash, Facebook ended up entering into direct licenses with performing rights organizations like ASCAP, BMI, CSAC, GMAR, labels, publishers, and also the aggregators as well. Aggregators being like CD Baby, TuneCore, DistroKid, Songtrust, Audion. Now, note that Facebook's licenses with music publishers, at least the major music publishers, they do cover sync use for short and longer form videos. And so basically the major music publishers have agreements in place with Facebook, and those agreements allow for users to upload covers, upload these musical compositions that these performers have decided to cover onto the Facebook platform in short form and longer form videos. Now, that doesn't mean that every single music publisher has an agreement in place with Facebook. It doesn't mean that every single aggregator has an agreement in place with Facebook. But at least as it pertains to the major music publishers, they all do. And that means that at least for popular songs that are owned and controlled by these major music publishers, it's probably going to be okay to upload a cover of one of those songs that's owned or controlled by one of these publishers to Facebook. Now you might be wondering, well, how do I know who owns or controls a particular musical composition? Just a quick thing that you can do is go and look through ASCAP or BMI's repertories, and you can actually just search by song title or by artist or songwriter and find particular songs, and then just click on them, and then you can see who the publishers are. So that's just one way to just kind of find out who the rights holders are as it pertains to the musical compositions. Also, Facebook has developed its own detection, technology, and copyright management system, and it's twofold. The first fold being Audible Magic. And so Audible Magic is actually a separate company, and it engages in blocking the use of sound recordings. And so a lot of labels will affiliate with Audible Magic and will upload their catalogs to Audible Magic and tell the company, hey, Audible Magic, if you detect my sound recordings on Facebook, I want you to block them. And then Facebook engages Audible Magic to deal with blocking along with copyright compliance. And the second fold of Facebook's detection and copyright management system is Rights Manager. And so it's kind of similar to YouTube's content management system. And if you are a rights holder that's been accepted into Rights Manager, you can then decide to block or monetize or apply attribution or report as it pertains to your particular works. Now note, with Facebook, you're dealing with the same problem as YouTube. Covers aren't able to be detected, and it's very difficult for compositions to be detected in live streams in general, because this is a different recording of a particular musical composition, and musical composition data is going to be tied to one specific sound recording. Now, this next slide, we are going to be talking about Facebook's live streaming controversies. And I got like a slew of emails about this back in August. I guess it was August. So first of all, you had issues on Facebook with DJs who were live streaming, but their videos, their live stream videos, were being muted or taken down. And one of the main reasons why that was happening is a lot of the time these DJs are utilizing really popular sound recordings in their sets that are owned or controlled by major labels. These major labels all utilize Audible Magic to block the use of their recordings on Facebook. And so automatically you would just deal with problems of the DJ set beginning, utilizing one of these sound recordings that is maybe under controlled by a major label, and then it just being automatically blocked because of the Audible Magic blocking technology. Then you had the music listening experiences debacle. So Facebook had updated its live streaming guidelines, stating that it was, quote, banning music listening experiences. And because we're talking about Facebook, Facebook, of course, just did not even define what that meant. And that caused artists to be confused. It caused lawyers to be confused. I was actually emailing a couple of lawyers back and forth, and we were like, what on earth does this mean? So it took a couple of weeks, but Facebook later clarified that traditional live music performances, like filming an artist or a band performing live, are permitted on the platform. But that the greater number of full-length recorded tracks in a video, the more likely it may be limited. And further, as it pertained to live streaming, there should, generally speaking, be some sort of visual element involved to it. Now, that's bad news for DJs, because they utilize a lot of the time sound recordings that they don't own or control. And so between the blocking technology and between the new guidelines that Facebook has released, they're just in a predicament, because the technology will either block the use, or if their uses of these non-owner controlled sound recordings aren't blocked or maybe aren't detected with the technology, they're going to be violating Facebook's guidelines. So some Facebook live streaming advice. 1, just don't even bother live streaming sound recordings which you don't own the rights to. Either 1, you'll end up with your live stream being muted or taken down, which also could result in your Facebook page getting a strike. And if you get a certain amount of strikes, your whole Facebook page can just be completely taken down. Or you could just deal with takedown notices, and you're just violating Facebook's guidelines nowadays. And, you know, really the only way, I mean, it's hard to even conceive of any way around it. Maybe the DJ should just go to the labels that own and control these particular recordings that the DJ is wanting to use. But still, when it comes to seeking licenses like master use licenses and sync licenses too, the labels and the publishers can quote any amount of money that they want to. So honestly, it's kind of a losing battle for DJs right now if they're using recordings that they don't own or control. Now, as it relates to covers, I saw like 20 different people ask questions like, can I cover a song on Facebook? Honestly, covering a song on Facebook is probably fine because Facebook does have deals with at least the major music publishers, which incorporates sync language into it. And then, you know, even if particular publishers don't have agreements in place with Facebook, due to the lack of sophistication of detection technology as it relates to compositions and live streams in general, it will be very difficult, if not impossible, first of all, for the technology to even detect your cover, right? But furthermore, even if that is not detected, the other circumstance that might happen would be maybe a music publisher or rights holder has somehow stumbled across your live stream and has listened to it to the point at which the cover is played. And then at that point, maybe you'll get a takedown notice. But I mean, I think that would be pretty rare. And at least after talking to different lawyers who work with some of the major music publishers, they were of the opinion that people really shouldn't be worried about just covering songs on Facebook. So that's something that I would not worry too much about. But I would not, under any circumstances, stream sound recordings that I did not own the rights to. So sorry, DJs, kind of sucks. Now let's talk about Twitch. Twitch has been in the news recently for a plethora of licensing issues on the platform. Twitch has no sync licenses with music publishers as it relates to the streaming platform. And it also has no detection or copyright management system for music publishers. Now, keep in mind that it really needs to have these licenses in place with music publishers that cover sync because Twitch live streams are archived. And then that means that sync is implicated. Now, Twitch does have blanket licenses with the performing rights organizations, but at least after some talks I've had with some various music publisher folks, many are wondering if composers and publishers are even being paid performance royalties in connection with Twitch. And just a quick word of advice, if many are wondering if composers and publishers are even being paid, they're probably not being paid. And further, as you'll see in the next slide, Twitch is honestly weaponizing the safe harbor of the DMCA. Now, Twitch's licensing issue saga has just been really interesting to me because you have a company that is, owned by Amazon, like the most valuable company on earth, that's run by the wealthiest person in the world. And Twitch has had the benefit of seeing what happened with YouTube and what happened with Facebook, and that YouTube and Facebook ended up entering into blanket licenses with rights holders that allowed the rights holders to choose how their works were used on their relative platforms. But with Twitch, it actually has agreements in place with music publishers in connection with its separate karaoke app called Twitch Sings. So it makes me really wonder, why Twitch's legal counsel thinks, oh, well, for the karaoke app, we need licenses in place, but not for our streaming platform. But that's just another conversation to have. Now, Twitch has partnered with Audible Magic to scan live streaming content for unauthorized sound recordings. And when labels decide to affiliate with Audible Magic, along with telling Audible Magic, block all of my recordings on Facebook, they can also say the same thing for Twitch. But what's interesting with Twitch's partnership with Audible Magic is until June of 2020, it wasn't utilizing Audible Magic to scan video clips from live streams that were sitting on the platform. Sometimes you would have situations in which users would like cut up a live stream and create like a best of video. And those videos that were sitting on Twitch weren't being scanned by Audible Magic. And as a result, you have the RIAA, which submits like 2,500 takedown notices to Twitch in the month of June, at which point Twitch then told Audible Magic, okay, we'll scan these videos too. Even more recently, Twitch also announced a new feature called Soundtrack by Twitch, which provides pre-cleared music to its streamers. And so this is particularly interesting. When I did a pre-recording of this particular topic last week for a group of lawyers, within an hour, Twitch ended up coming out and going into more in-depth how Soundtrack by Twitch would work. And it seemed like it was going to be in the form of like a music library that streamers could go in and just choose what music would be used in the streams. However, that was actually not the case. Basically, Soundtrack by Twitch is not providing pre-cleared music in the form of a music library. Rather, Twitch will be providing music in a non-interactive manner on a separate channel from the live stream video. So then that means that when the live stream video is archived, the pre-cleared music won't be able to be heard because the music is being played on a separate channel. And so Twitch's strategy is twofold here. By not including the music in the live stream when it's archived, the platform is trying to escape having to deal with sync licenses. And further, since the music is being used in a non-interactive way, non-interactive meaning you're not choosing what songs are played, it's more of like a Pandora or Sirius sort of situation. And because the music isn't being stored on the separate music channel, it's also attempting to avoid securing mechanical licenses for music publishers. So it'll be interesting to see what happens with Twitch. Just within the last few days, all of the major music publishers and songwriters, advocacy groups have sent a lot of demand letters over to Twitch saying that they need to change their tune and actually license music because all of their works are being used on the platform and no one's getting paid. So it'll be interesting to see whether or not Twitch actually does change its tune, because if not, I foresee probably in the near future a copyright infringement lawsuit being filed. Now let's start talking about monetization. Now, performance royalties. What's been really cool are some of the performing rights organizations have expanded their setlist submission systems to also cover live streaming. And so ASCAP on Stage, whereby people used to just submit set lists for playing sets in a particular venue, ASCAP's now expanded that to live streaming. And so you can submit your live streaming set list to ASCAP on Stage. CSAC, at least according to Billboard, has incorporated the same thing. And apparently that was even in place before the pandemic. But I've talked to a few people and they were saying that they were having issues with it and they couldn't figure out how to submit set lists for live streams on CSAC. And so if you are with CSAC, it's probably worth a conversation with your CSAC rep so you can figure out how that works. Now, I know that most of the viewers are here in the US, but there is one viewer in particular who is from Toronto. And one thing I wanted to include was how SOCAN is approaching performance royalties in connection with live streaming. So I thought it was pretty cool. Basically, as it relates to Facebook and Instagram live streams, they could be eligible to generate a total of 150 Canadian dollars, with that amount being split amongst the rights holders of the musical compositions. And in order to be eligible, the live stream show has to be at least 30 minutes long, or consist of 10 songs while having been viewed by at least 100 people. All of this can be evidenced via a screenshot. And so I just thought it was pretty cool that they came up with their own system and payout mechanism. Now let's talk about in-platform monetization, meaning money that you can earn in like the YouTube platform or in the Facebook platform or in Twitch. So on YouTube, if you have 1,000 subscribers and 4,000 hours of watch time, you can qualify to have ads run on your videos. And at that point, that means that you can then earn ad revenue. YouTube also has YouTube Premium revenue, which comes in the form of subscription fees from folks who decide to use the paid YouTube service. YouTube also has what they call Super Chat, and that allows users to pin comments at the top of a comment section of a live stream in exchange for money. With the more money that a user pays, the longer that the comment will stay pinned to the top of the comment section. And here, YouTube will take a 30% commission, and the particular content creator will end up with the other 70%. YouTube also has a channel membership feature for YouTube channels with more than 30,000 subscribers. And so basically, a viewer would just pay a subscription fee to the channel in exchange for certain perks like exclusive live streams. Now, Facebook is following along the YouTube path. And in fact, right now, Facebook is beta testing in-stream ads for live streams. And in order to qualify for this beta testing program, your page has to have 2,000 or more followers. And the page also has to have attained 300 or more concurrent viewers in a recent live stream. And at least on your Facebook page, there's a way that you can kind of go into your creator studio and then see whether or not your page would be eligible for the beta testing. Facebook also has its own subscription service for pages, and it also has its own virtual currency called stars. And basically, someone can buy 95 virtual currency stars for $1.99. And then those stars can be used to tip live streamers, with 1 star equating to 1 penny. And with Twitch, you can start earning revenue on the Twitch platform once you reach affiliate status. And you reach affiliate status by having 30 followers and 500 total minutes of broadcasting during 7 unique broadcasting days, and an average of 3 or more concurrent viewers over the previous 30 days. I know that's a mouthful. You won't remember it. I won't remember it either. So that just kind of goes to show that, you know, all of these platforms, whether it's YouTube, Facebook, Twitch, in their terms and conditions, it says that they can change their monetization guidelines, any of their terms and conditions guidelines at will. So, you know, if you're ever wanting to know what the monetization criteria is for a particular platform, just go back and check, because, you know, it could be that tomorrow everyone decides to change everything. Twitch also has its own virtual currency called bits, and viewers can use bits to cheer for live streamers in the comments sections of a particular live stream. And so live streamers then end up earning a portion of the payment for the bits. Now, SoundCloud recently, just within like the last month, has partnered with Twitch. And basically this partnership allows for SoundCloud artists to be fast-tracked to affiliate status, meaning that they don't have to meet all of this criteria above. And keep in mind that SoundCloud is no longer just a streaming platform. Rather, it's also emerged in the aggregator kind of distributor space. And once someone has reached the level of affiliate status with Twitch, they can then work towards becoming a Twitch partner, which unlocks additional features that I'm not going to talk about today. So then we have out-of-platform monetization, which is just very simple. just providing links to your PayPal, to Venmo, or to your Cash App. And what's great is there's no criteria that you have to reach. I know that it's kind of daunting when you look at all of the criteria, whether it's YouTube or Facebook or Twitch. It's like there's a lot of things that I have to be able to meet in order to start having ads run on my videos, or in order to implement channel subscriptions. But with this out-of-platform monetization, this money is going to go directly to you. You don't have any criteria to reach, and it's just as simple as just putting those links out there on your live streams. Now let's explore some other legal considerations, such as ownership issues. So, in the context of labels, if an artist is signed to a label, the recording agreement between the artist and label will likely state that the label is going to own all audiovisual works and recordings that are performed during the term. So, if that's the case, if that's the language in the recording agreement, that means that your archived live stream videos are going to be owned by the label. And if that's the case, then the label will also have the right to control the monetization. Now, there's also issues as it pertains to re-recording restrictions and recording contracts. A re-recording restriction sounding something like the artist agrees not to perform or record any musical composition that is recorded or delivered to the label during, for anyone other than the label, for a period of X years after the agreement is terminated, or for X years after the records that contain these musical compositions are released. So you could have issues where by performing in a live stream, whether it's archived or not, it might actually violate the re-recording restrictions in your recording agreement. And just performing a live stream that isn't archived might not even be a way around the issue. It all just depends upon the language in the re-recording restriction. So ultimately, it just comes down to going back and looking at your recording agreements. So, go back and look and see, what it says about ownership of audiovisual works and the underlying recordings in the audiovisual works. Look and see if there are re-recording restrictions in that recording agreement. And then, look and see, how broad are these re-recording restrictions? Because then that will determine whether or not you might be able to get around them by just doing a pure live stream that's not archived. Now, I know that this probably sounds daunting, but just think about it on a practical level. It's probably not going to hurt to have a discussion with your label about this issue, because it's not like a label just wants its artists to just sit around and twiddle their thumbs until everything opens back up. The label wants the artist to be out there and performing and being, relevant, just because there's so much content out there. And by not being out there and having a digital footprint and performing, you'll just get lost, right? And people will forget about you. So it's ultimately in the label's best interest for the artist to be, live streaming their sets. And so that's just a conversation to have. And then what will be really interesting in the future is how this issue is dealt with in future recording agreements. It might be that parties decide that when it comes to the re-recording restrictions language, that they want to, limit that and exclude live streaming from that. So, we'll just see what happens in the future when it comes to that. Then there's also ownership issues as it relates to multiple performers. If there is no agreement in writing between members of a band and the band is all performing on a live stream, then all of those band members are going to jointly own that live stream, the audiovisual element, along with the recording that's contained in the live stream. So, that's just something to keep in mind. And let's say that a band decides that they want to have a guest performer come and perform on a live stream. If there's nothing in writing, then that guest performer would jointly own that copyright in the audiovisual work and in the underlying recording in the audiovisual work. So that means that it probably makes sense for the band to present that guest performer with a guest release that incorporates work for hire language. So then the band will own the copyright in the work that the particular guest performer contributed to. And so, this is also just something to keep in mind when it comes down to band partnerships, agreements, and company agreements, and just making sure that, live streams are accounted for in there so there's no confusion as to ownership. Next. So this is an issue that I explored on another panel with two other entertainment lawyers here in town, Amy Mitchell and Buck McKinney. And so in this, it was basically like a whole scripted pandemic panel. And I played the role of manager, and Amy Mitchell played the role of artist because she's also a musician on the side. And then Buck McKinney played the role of Amy's lawyer. And so as we were talking about live streaming, I brought up, well, Amy, as your manager, I should be able to commission not only the in-platform monetization, like ad revenue on YouTube, but also out-of-platform monetization. So like the PayPal money and the Venmo money. And so, her argument that she retorted back was, well, that's just like taking money out of the tip jar. That's not fair. And so, then Buck comes in being the lawyer out of us three lawyers that were all playing roles. And it all just comes down to the wording in the contract. In most of these management contracts, the commission language is super broad, including like, right to commission gifts and bonuses, basically anything, any compensation related to the talent's career as, as an entertainer. And so that means that because the commission language is pretty broad in most contracts, that in a lot of cases, you might have circumstances in which managers could commission this money. And that might mean that artists just don't understand this. They're like, well, that's not fair. These are tips. But, it's, I think, good to keep in mind that a manager, if the manager is good, is going to be dealing with the marketing and the promotion and helping to get the live stream up and making sure that, people are going to be engaged and really planning it out for you. And that it's just really another revenue stream that a manager can tap into because managers just tap into all the revenue streams. And just on a practical level, it could just be a conversation to have with the manager. And, a lot of managers would probably be, nice and just say, well, you know what, I'm not going to just commission your Venmo money. It's just going to be a hassle and I don't want to do that. So ultimately, just like on the label side of things, this is just a conversation to have. But, it's important to keep in mind. And I foresee this being something that people start beginning to think about over the next few months, particularly because live streaming is here to stay. If you talk to just about anyone in the music industry, they understand that, yes, COVID propelled this sector, this live streaming sector. But because it's just so easy to do, it's going to just become a part of everyday life in the music industry, even when people can go back to performing in clubs. So in conclusion, I know that this was a ton of information, but I hope that you understand that there are two different types of live streams, that you have the pure live stream that's not archived, and then you have the archived live streams. I hope that you understand that, as it relates to different platforms and their relationship with rights holders, the music publishers and composers always end up getting the shortest end of the stick. Because they're the last ones that people end up entering into licenses to get permission to utilize their works. And then you also have the compounded problem of the lack of sophistication of detection technology. So, that's problematic. And, keep in mind, remember that if you're with like ASCAP or CSAC or SOCAN, you can submit set lists for your live stream. So that's just another way to earn some extra bucks. I hope that you understand that there are ways to make money in platform. Granted, you have to meet some hurdles, but right now might be the time to start working on meeting those hurdles. A lot of people have free time. It might be something as simple as going out on your Facebook page and saying, hey, everyone, here's a link to my YouTube page. Please click subscribe. I don't know about y'all, but you probably have friends that are part of like, pyramid schemes and multi-level marketing that just constantly, ask you for things. So, why not just tell them, hey, why don't you help support me and my career by going and subscribing to my YouTube channel? It's not difficult. I hope that you also understand that, hey, when it comes to just live streaming in general, just put all of your, PayPal information, Venmo, Cash App information. It's just really easy to do. And everyone uses, those platforms these days. And it's just a way for you to earn some money. And it's a way for you to, not have to deal with a middleman that's taking a commission. Now, I know that some people had submitted questions about ticketing and platforms. I know that Facebook recently, I guess it was like in August, they have started dealing with ticketing in connection with events and live streams. I just don't know anyone who's used it yet. So I think probably the answer there is to, maybe ask some of your friends, like, are they incorporating ticketing into their live streaming? And ask, what's working and what's not. It's really difficult right now to provide just like practical guidance of, what's the best day to go and do a live stream, or how can I ensure more people are watching, or, how can I ensure I make the most money? It's really hard because this is so new and lots of people are just, doing it by trial and error. My whole thing is I like to throw as many things up against the wall as possible and see what sticks. I don't think that it would hurt to look at live streaming like you look at performing in a venue. If you're in a band and you're going to be performing the same set over and over again, well, then it probably doesn't make sense for you to do a ton of live streams in a month because, people will think, oh, well, I can see it next week, or I can see it the week after, or the week after, and then people will just keep putting it off. But I think that if there are ways in which you can make your live stream more unique, or you add on guest performers or things like that and change things up, well, then, it would make sense to do it more often. Like I know that, for example, like the Band of Heathens, every Tuesday night, I believe, they have a live stream that they do, and they invite a guest each week. And so that changes things up. And so it makes sense for them to, do it weekly because they have a new guest on each week. So I guess this is just kind of a long way of saying that it's really hard to provide strategies at the moment because everyone's just scrambling to figure it out all at once. And so, just talk to some friends and see what they're doing. Look around and see what's working for other people. No point in reinventing the wheel if you see things are working for other people and you can try it yourself. And finally, just be aware of ownership issues and revenue sharing issues. It might make sense for you to revisit recording agreements that you have, or band agreements, band partnership agreements, management agreements. And, finally, when you're inviting guests onto your live stream, if you want to own and control the copyright and that audiovisual work and the underlying recording, well, then you should have that guest performer sign a release that incorporates work for hire language in it. So with that, we are concluded. And wow, okay, I see that there are a lot of comments. So
yeah, you got quite a bit, Gwen. Thank you so much. This has been so great. I want to answer some of the questions, but I wanted to cover a couple of things just first. Number one, we didn't talk about it earlier, but I wanted to talk about the clinic that you and Mike Tolleson have every Wednesday. This is a great service, and Tala, we've sent people over there. They are willing to speak with you, basically pro bono, every Wednesday, and you can call and schedule that consultation with them. Can you talk a little bit more about that, Gwen?
Yeah, if you just go to artsandentertainmentlegalclinic.com, a form will come up for our legal clinic, and then it's basically just asked for like your name and just like some contact information, and all of that comes to me, and then I will find a time for you on a Wednesday afternoon between 2 o'clock and 6 o'clock in which you can meet with myself or Mike or both of us, just kind of depending upon how many people have signed up for the Wednesday.
So it's a great service. I would highly suggest it. And then, they do refer to Tala also. So if you need more help than the 30 minutes, then they have referred to us. So it's just a good place to go if you just have a few questions. And as you can see, Gwen has lots of answers. So I just wanted to mention that again. Another question we had over and over again, Gwen, was the slides. And I just wanted to remind people that this will be available on November the 21st. And I will check with you, Gwen, if the slides are going to be able to be separated and we can put them on our resource page or not. And we can talk about that. But the content of the video and the video will be available on November 21st.
Yeah, so, it will be available after November 21st. And while, I wanted it to be available for everyone right now, the problem is I've made commitments to other organizations in which you have some lawyers paying a pretty decent chunk of change to see this along with some other presentations. But my feeling was, look, this is all information that everyone needs to know. Artists need to know this. I know everyone's like super confused about this area. And so I at least wanted to make sure that at least artists and other creatives had the ability to, see this, before the end of November. So once that happens, I'll be sure to put that out on Facebook and Instagram. And I know that that will be out on the Tala page as well.
That's great. We so appreciate you sharing with us first, and we're glad to get the scoop over here. Before we go to some questions, I just wanted to mention a couple of things. So from listening to you tonight, I'm assuming that if you are performing originals or you own part of the copyright of what you're performing, or if something's in the public domain, that it's basically okay to move forward on any of these platforms?
Oh, yeah, absolutely. Yeah, if you own the rights to the music that you're performing, you should not run into any issues, provided that the platforms don't release some sort of guidelines, sometime down the line saying they just don't want anyone to live stream anything. But at least for right now, if you own and control the works, then you're in the clear.
And then if you were working with the label, your advice was to check your contract or your recording agreement to find out what rights they may have?
Yeah. If you work with a label, it's time to just go back through and look at that contract. Honestly, it might be that the label hasn't even thought of this or these issues, but ultimately, people will begin to start thinking about this. So it's just good to go back and look at that contract and just see and make sure that, am I violating a re-recording restriction? Could the label say that they own, these live streams that I'm doing? So just go back and look at that contract.
And then on the cover side, which was tons of questions on our registration page about that. So if you're going to do some covers, would you say it's better to go ahead and go with YouTube or one of the platforms that does have licenses versus just try to do it on your own? Is that what you would probably recommend?
Absolutely. Doing it on YouTube or Facebook, that should be fine. But, if you're doing it on your own website and the live stream is able to be available on demand, you yourself as the owner of the website are going to have to go out and get the sync licenses because you're using this cover in an audiovisual work that can be replayed. So I would suggest just, sticking to YouTube and sticking to Facebook. I mean, if you want to, you can do Twitch as well. Me personally, I'm not a musician, but let's say I was a musician. I don't think that I would want to be streaming music on a platform, live streaming music on a platform that isn't securing licenses with rights owners and that's not paying rights owners. I just would not see that as being like a good look. I'm also just a very stubborn person and super opinionated. So, that might not matter to you. But ultimately, I would just probably stick with like Facebook and with YouTube because they have agreements in place with most of the publishers.
Great. And then the last thing before we start taking some questions, you just covered this at the very end, but if you are with BMI ASCAP, are you able to just go online after your live stream and report that, or do you know what's the easiest way to report that?
So, okay, first thing, ASCAP and CSAC and SOCAN offer these services. BMI has not incorporated that yet. So I imagine they probably will. You know, a lot of this is just kind of trial and error, right? But at least with ASCAP, it's like when you're going on ASCAP on stage, you should be able to input your live stream set list in there. I haven't done it myself, but I know it's possible because I've talked to a representative over at ASCAP, and they're like, "Oh yeah, like you can do it. You know, whether it's Facebook or Instagram, or wherever." And so, if you have trouble with it, then I think it just means you should call up ASCAP. You might have a representative you've worked with, and they should be able to direct you. And same thing with CSAC. I've had a couple of people contact me and say they don't see where they can do it on CSAC, but CSAC told Billboard that they have this ability. So I don't see them telling that to Billboard if they don't. So I think that's also just a conversation to have with your rep over at CSAC.
Okay, great. So I think we have a little bit of time. Are you willing to take a few questions?
Yeah, I'm kind of looking through.
There's someone asking about transformative use. I know that's kind of a can of worms. Would you be able to address that just for a minute?
It's really hard in the context of this presentation of getting into the fair use landscape. It's something that would probably take a solid 20 minutes of explanation. Now, if you are getting to a point where, maybe you're utilizing music in a different way, like, I don't know, let's say that you're evaluating a piece of music and you're like, I like this part of this song, but, this chord would actually be better than this chord. Something like that where you're changing the meaning, that would be more along the lines of transformative use. But I say that if you really want to spend some time and talk about fair use, sign up for the legal clinic because it's very content heavy and will involve quite a bit of discussion. And the problem is when you're talking about fair use, it's a gray area. And so different lawyers will give you different answers. And likewise, different circuits and different jurisdictions and different judges will have different interpretations. So it's just so gray. And it also really involves knowing all the facts about your work and how you're using a particular copyrighted work in your work to really give like a good analysis. So sorry, I can't really answer that question now, but I promise you, if you sign up for Legal Clinic, we can talk about fair use as much as you want in about 30 to 45 minutes of time.
So that sounds great. We had some questions about theater and dancers. We had a comment that, let's see, I'm gonna pull hers up. She wanted to talk about dancers. She says with original compositions, but we also had a question earlier about choreography. And then a couple of other questions going into theater, spoken word, some of the non-traditional live music type live streaming. There was a comment on here that I guess dancers that are dancing to music, they would also need to worry about that composition if it wasn't original. Is that correct?
Yeah, they would. And, it might be that you're talking about a musical composition that is embodied in a sound recording that the dancer is dancing to. And so, whether or not in a live stream that would be okay, it just comes down to, first of all, like if you're talking about, dancing to a sound recording that you don't own or control, that's going to be difficult because of the detection technology, Audible Magic, or whether it's Content ID, because the owners of the sound recordings, the labels, they probably, in many circumstances decide, you know what, the use of our sound recordings are going to be blocked. But if you maybe have, like, I don't know, someone performing a cover of a song with another person dancing, or maybe you're performing a cover while you are dancing, I guess you run into less issues because the detection technology is pretty bad. And then it would come down to knowing, it's like with the agreements between, like, for example, Facebook and the major music publishers, those agreements cover, sync. But I don't know 100% if brand rights are included in there. But it's just going to kind of come down to the license that's in place between the music publisher and the platform. But if you're going to do it, I think it's probably better to do it on Facebook or YouTube really than anywhere else. So sorry, and I know that probably for some of these questions, I'm not giving clear-cut answers, and that's because there's not clear-cut answers. And I know that probably people hate it. It's like, just tell me yes or no. The problem is a lot of these just involve really diving into the specific facts. So, I apologize ahead of time if I'm not able to 100% answer your question.
That's okay. We know you have a clinic, so they can always know where to track you down. So I'm going to this is another one that we would need more information on. I can tell you about minors. There's a lot of laws regarding minors and using their likeness. And we get actually at Tala, we've had quite a few people that have complained because their children have been involved or unknowingly in a photograph or a video. So I don't know if you just want to address that simply. I think that's going to be another conversation about exactly how you want to use that, but you really do need to be careful.
I would agree, be careful. I really don't, we don't really see that many issues with minors come through here. And in fact, I'll be watching a webinar in a few weeks, one topic of which involves, issues surrounding minors in audiovisual works. And so, I might have a better answer, in a few weeks once, I've listened to this webinar by someone who literally their whole life's blood is dealing with, issues surrounding minors in audiovisual works. But, I would definitely be really careful as it relates to minors and live streams.
And so our next question is asking if it matters if you have a Facebook personal page or a Facebook band page, or are those basically the same when you're looking at the licenses and the
same thing.
Let's see. Let's see. We've got. This person says they're being muted even though the artists own the copyright. Is there anything that they're doing or they could do differently, or would you have any advice for them?
So I guess my first question would be, do the artists actually own the copyright of the recordings that are being performed? So that would be my first question, because it might be that artists are signed with a label and the label has either put in Content ID or in Audible Magic that they want those recordings to be blocked. I would really need some more information about this. It might be that, there's maybe, I don't know if there's samples that are being used, but I would really just need some more information. Artist copyright. I mean, if an artist is performing her own original musical compositions in a live stream performance, and there is no label involved, then there shouldn't be muting issues, unless there's something else going on in the video or something else incorporated in the video that the artist doesn't, own the rights to. So, yeah, how about you reach out, because I'm curious as to, what's happening here and what platform it's happening on. So, feel free to reach out to me and we can discuss this further.
We have a question on Instagram and Periscope and playing covers on those platforms.
So Instagram is owned by Facebook, so it should be fine for you to perform covers on Instagram. I am not sure about Periscope. It was not the focus of my long legal guide to live streaming. But I have no problem looking into Periscope. I just don't really know many people who are using it. But I have no problem looking into that. So yeah, you're probably fine on Instagram. Periscope, not sure, because I don't know if Periscope has agreements in place with music publishers.
All right, we've got some questions about copyright and choreography. I'm just going to pull this one up. I'm not really sure. This may just be a pure copyright question, but does performing the original choreography assign the same rights to the dance work? And I'm not really sure. I think this may be, I don't know for sure exactly what this question is, but if the choreography, if it's original, even though the composition is not or is licensed to someone else, would still be copyrightable as choreography. I'm not really sure what that means. Did you have any other comments about copyright and choreography for dancers? Because I do know there's a couple of dancers on here.
Yeah, I feel like I would need to ask a few more questions to the person who posed this question before I'd really be able to give some sort of answer. But what you said, Elisa, about choreography is correct. So,
and then just a couple of updates from the minor. He said that does a waiver apply? So of course, yes, you can always have a contract or a waiver for the minor to be used. And I would suggest that you just contact Gwen specifically, and she should be able to answer those questions for you. And I think that's about all that I saw. And I hope I didn't miss anyone. I ran through those pretty quickly. So any last parting comments?
I can't really think of any other. I mean, this is a lot of content, and I know that it's probably going to be hard to remember a lot of this stuff. But keep in mind that this will be available after November the 21st on Tala's YouTube page, so you can go back and refer to it. And then I will try to figure out about the PowerPoint situation. But even if this is available on YouTube, you can still go through and see the PowerPoint too. Yeah, thank y'all so much for joining me, and I hope that this made sense. This was originally catered to a bunch of lawyers, so I hope that it was able to be broken down enough for non-lawyers to be able to understand this too. And if you have other questions, feel free to reach out to me. And check out our legal clinic because, we have this free time every Wednesday afternoon that we'd be happy to meet with you and discuss, any live streaming questions or entertainment related questions you might have.
Great. Thank you so much, Gwen. And thanks for joining us, everyone, for tonight's webinar. I'm so thrilled to have you on our board and work with you. To tell everyone that's still watching, I call Gwen a lot if I have questions, and she always takes my calls. And that's just priceless to me in my role at Tala. And I just thank her for being on our board and being such a supporter of artists. And she's really an ally to our organization. If you want to receive emails about future programs, you can go on our website. And if you click on the homepage, you can go to any other page from our homepage. And on the right-hand side, it will say join the newsletter. The newsletter is mainly just announcements of our programs, so you won't be hit too hard with hopefully things that you don't want. It would just be announcing our programs. We have one program for public artists coming up on November 12th. It's a lunchtime program starting at 11:30 in partnership with the Carver Museum. We're going to be talking to artist Ryan Runcie and attorney Adrian Resendez about public art contracts and what you need to know if you're doing a large scale public artwork. I know these are a lot of music people, but tell your art friends that that is coming up. You can go to our website. Again, that is November 12th at 11:30, and it will be a webinar. And that's it for this evening. Everyone have a wonderful night, and we'll see you again soon.